Today's topic is, should I put assets in my child's name or in a trust? We have probably 20 different topics in this subject area. One problem putting assets in the name of your children is it exposes your assets to your child's debts, creditors, and potential bankruptcy. So if a child has a horrific auto accident or they have to file bankruptcy, the asset's gone and there's nothing that you can do. It can be for sale or it could have a lien on it. Another problem is you put it in a child's name and they're married, and in a community property state, they commingle the property with their spouse, and the spouse files for divorce and calls your property half of the community property. Another problem is if your child dies suddenly, your property would not necessarily go back to you. It would be divided between the surviving spouse and the children of the child. And, so inheritance from other people. If you have your name, child's name on an account, it shows as ownership, not just as a signatory. You cause problems within the family. So I had a client that had his house in joint tenant with his son. He had a son and a daughter. They were supposed to split the assets equally. It said that in his trust and his will, but the house title was in joint tenancy. So when he died, all the property went to the son, and the daughter was left out because of the way he was holding title in his son's name as joint tenants. Another problem of putting assets in your kids' names is if you buy a property, let's say a real property, a house or something, for $100,000, and now it's worth $850,000, you give that house to the child, and your basis, tax basis, is that original purchase price. So you're exposing your child to capital gains. Now, if you were to leave the property in your name and then you pass away, then your child gets a stepped up basis under Internal Revenue Code section 1014. And if the child sells it the next day, then there would be no capital gain. Okay. So another problem with putting it in your child's name is loss of control. So it does happen. You have a reliable child and then they fall on hard times. You put them on as an owner on the account or a signatory, and they start taking money out of the account without your permission. And I've seen it happen. It's not, it does happen. That's all I can say about that. There's another problem of putting property in your child's name. Say your child had a horrific auto accident, became incapacitated, and needed extensive medical care, such as Medi-Cal or Social Security or disability or government entitlement benefits. If they have assets in their name, they are required to spend all those assets before going on the public assistance. So it's called spend down. So another unusual problem is, let's say you put son and daughter on an account, son or daughter, and then the son or daughter becomes incapacitated and their spouse, your in-law, is now in charge of every asset that they're in control of, and your child is no longer in control, and you're at the mercy now of in-law who might have malevolent intentions. Another problem of putting property in your child's name is, let's say you want to move to another house, sell your home, downsize, whatever, and your child's name is on there, or you want to refi, you have to get the child's permission to do the refi. And if you were to sell it, the child could claim half the proceeds of the sale. Another problem of gifting property, if you gift over $15,000 a year per beneficiary, or $30,000 per married couple, you have to file a gift tax return with the IRS, and it would be considered a taxable gift, the amount above $15,000. If you gave a $1 million house to your son, then $1 million minus 15,000 is the gift tax to report. On the other hand, an advantage of putting assets in your children's name, if you are fairly well off, say if you're single and have more than 11,700,000, or if you're married and your assets exceed 23,400, then your estate tax, inheritance tax, will be less by the amount of the property that's not in your estate. So another idea is to think of yourself first. It should be your highest priority is have your assets available for your own care, which makes sense. You may not be able to get it back in times of need. Another, this is on the plus side, advantage of putting property in your children's name. Let's say you're getting older and you might need a skilled nursing facility that might cost you $6,000 to $8,000 a month, and you could file under Medi-Cal that would pay for it, but you have too many assets, and so they want you to spend it down. If you transfer the assets to a child more than 5 years ago, then you can still qualify for the public benefits without requiring spend down of your own assets first. Another problem of putting assets in the name of a child is in California, a child under 18 cannot own property greater than $5,000 without a guardian. So it causes that problem. What the main problems, to summarize on the risks of putting property in child's name, are what I call the magical 5 Ds: the child's debt, divorce, disability, death, or doing a dumb act. So that's the problem. Some people say, oh, you put the property in the child's name to avoid probate. Oh yeah, poor man's estate plan. It's not worth it. The high cost of probate, the delays, a trust is way better, and you don't need all that. Another alternative that's not so good but does work is you could give your child a power of attorney, general power of attorney, so the child can manage your assets, but they have no direct ownership because they're only an agent on your assets. So their creditors cannot take those assets. Normally, what most people end up concluding is that having a revocable trust is the best practice because it's simple, it's common, and it's well known. Another possibility of putting assets in the name of a child is a Uniform Gift to Minors Act when the child is under 18 or 21, depending on the type of account and what state you're in. And those assets belong to the child, and they can't access the funds until they become of age. And that's frequently done. That's one way to get around the kids can't own more than 5,000 of assets. But there's a downside. Like in my case, I put money aside in the Uniform Gift to Minors Act. And then when my daughter became an adult, she went in and took 30,000 and closed out the account without any discussion. So that's a downside. On the whole, I'd have to conclude that putting property in the name of your children is not a good idea, and I would not recommend it. If you have any further questions, please contact our office.